Yes, Your Honors. If it pleases the court, I am Christopher Berman. I am the appellate. I am pro se. I'm representing myself. I would also like at this time to lodge my objection with the court to Mr. VUKELJA acting as counsel for Mr. DePaula, as Mr. DePaula and Mr. VUKELJA are co-defendants and represented themselves pro se in the lower trial court. And per Florida Bar v. Fig, 1992, a counsel acting in the defense of a party cannot be a co-defendant in the same action. Your Honors, this action, this appeal the standard of review of this appeal is de novo. There are issues of fact, there are issues of law, there are issues of reviewable error as well. There are two issues at stake. The first being the untimely dismissal of a motion for default judgment, my motion for default judgment, by the lower trial court judge without the motion being heard. And the second is the summary judgment dismissal of a well-pled multiple causes of action of my complaint for fraud, abusive process, torturous interference, and emotional distress that was lodged against the two defendants.
Let's deal first with, as you phrased it, the motion for default judgment. Have you procedurally moved to get a default against the appellees in this case prior to filing your motion for default judgment?
I filed a motion for default judgment, which was actually based on the June 13th hearing before Judge Maurice Guinta, when only one of the defendants, Mr. DePaula, had appeared. At that hearing, I had motioned for qualification or of representation of the defendants as they appeared to come and go at will. The original court notes from the first hearing list Mr. VUKELJA as pro se, even though he is an attorney. According to Rule 454.18, anyone can represent themselves as a pro se, including attorneys. At that time, I had motioned for a clarification of their representation. To which Judge Guinta had said to Mr. DePaula, you must qualify, you must tell us how you're being represented. Mr. DePaula responded, and I have this in my affidavit, responded, we are represented as individuals, Your Honor, to which Judge Guinta had said, I would strongly advise you to be represented by counsel. This could cause issues later on. It's my contention that since Mr. VUKELJA had not appeared at that hearing, and since the case was against both defendants, he was in default. When I went to raise that issue at the November 8th hearing, the November 8th hearing was to be before Judge Traynor. Judge Traynor was involved with another matter. He turned the hearing over to Judge Hedstrom. Judge Hedstrom said when he entered the courtroom, I'm not familiar with this case. He said, I'm here to hear a hearing to dismiss this action, motion to dismiss. And I said, Your Honor, I also have a motion for default judgment, to which at that moment, Mr. VUKELJA stood up and said, Your Honor, there's no default, we're both present. I believe that Judge Hedstrom mistook the fact that the motion pertained to the hearing before Judge Guinta. He said to me, denied, and I said, he said, denied, I'm not going to hear it. If you want to argue it in appeal court.
Mr. Berman, what was the default? That somebody didn't show up at a hearing?
Yes, that's correct.
There's no authority that requires a party to appear at every hearing, is there?
Well, the case is against, the parties are pro se. Each party was representing themselves.
Subpoena them to be at the hearing?
Well, yes, they were motioned to be at the hearing. The original,
Them to be at the hearing. Did you issue a subpoena ordering their appearance at the hearing?
at that particular hearing, the original case, Your Honor, the summons for the original case was for both,
I'm not talking about summonses, I'm talking about subpoenas. Subpoenas is the way you force somebody to appear for a given hearing. A summons does not require anybody to appear in person for.
no, Your Honor, I did not issue a summons. However, on the original hearing before the court, both defendants received summons individually, and only one appeared. On the original court notes, Mr. VUKELJA is listed as pro se. Both defendants, even though they are attorneys, are pro se. I would like to...
I've read appellate cases where the appellate courts have addressed whether the lower court erred in granting a default judgment. And I've read cases where the appellate courts have addressed whether the lower courts erred in setting aside a default. But for the life of me, I've not read a case on appeal where the appellate court addressed that it was error for the lower court to deny a default. Have you ever read a case that addresses that square on?
I have not, Your Honor. I'm a pro se litigant, but I will say that under Model Code of Judicial Procedure, I think it's 2.6, there is a right to be heard. There's a right to be heard under due process of the 14th Amendment. I was not allowed to present my motion for default judgment. I was not allowed to state the facts of my motion for default judgment, which related to the fact that one of the two pro se defendants, the two parties, which were now adverse to each other in terms of how they were.
Are you aware of the judicial tenet that we, as a system, want matters resolved as much as possible, not always, but as much as possible, on their merits?
Yes, Your Honor.
So to summarily end litigation is difficult.
Summarily ending litigation is an ultimate sanction, and it was unwarranted.
And that happened to you later on your complaint, but you're saying your complaint shouldn't have been dismissed with prejudice, but the first point I want to argue is that, we should direct the lower court to now enter a default judgment?
No, I'm asking the appeals court to remand the case back to lower court. It should have at least been, I should have at least been given my right to speak and to address the court. But
Should the judge have also been given the leeway, for lack of a better term, to look at the motion, look at the face of your motion, and consider what has been admitted in the record, which prior to a motion for default judgment, a judge would be looking at the record in the court file to verify that a default has actually been entered, and be able to then rule upon the face of the motion and whether or not it's legally sufficient in denying the motion to enter a default judgment when a default hasn't even been entered.
Your Honors, Judge Hedstrom said at the beginning of the hearing, I'm not familiar with the case. He had not looked at the proceedings beforehand, and was not even aware at that time that I was going to raise a motion for default judgment.
Well, you had the other side taking the position, Judge, there's been no default entered in this case. At that point, it would be incumbent upon you to then contradict that in front of the judge by indicating, yes, Judge, I have a default right here, a copy is in the court file.
No, I was told to sit down. It was denied. He said, if you want to argue this, argue it in appeal court. I was cut off at that moment.
Okay, and there's a record of that, correct?
Yes, there is, and I also have I have also said that in my sworn affidavit, which is attached to my answer brief.
Well, what remedy would you want us to give you as a result of that? order the court to default them?
Well, Your Honors, they were in default.
So do you want us to order the court to enter a default?
Your Honors, I would like the entire case remanded back to the lower trial court because it was so full of confusion and errors. I brought a well-pled case with causes of action for fraud that was supported by case law, for abusive process that is supported by case law, the use of an illegal process after process for something that's unintended in the course of an action.
Okay, so you want us to send it back, not directing the court to enter a default, but to allow the litigation?
I would like, yes, Your Honor. I want, this was an untimely summary judgment. And one of the main issues, the main issue at this is when this hearing was concluded with Judge Hedstrom. Judge Hedstrom said he had directed both the defendants and myself to prepare orders to dismiss, proposed orders for each of our positions. My proposed order was to deny the defendant's motion to dismiss. The defendant's proposed order was for the motion to dismiss. He instructed us, I believe, both of us, to send the proposed orders to his post office box in Palatka so he could study them and study the case as he was unfamiliar with the case. I sent mine to Palatka. For some reason, the defendants sent theirs to the Seventh Circuit Court in St. Johns County. Now, this was November 8th. November goes by, December goes by, January goes by. Now it's getting towards the end of February, and I'm wondering what is happening with my case. So, I called the lower court. I spoke to Judge Trainor's office. They said Judge Trainor is no longer handling civil matters. This has gone to Judge Maltz's office. I called Judge Maltz's office. They said, we don't have the file. We don't know anything about this case. And I said, but there's a proposed order in front of Judge Hedstrom, to which Judge Maltz's JA said, well, I'll call Judge Hedstrom and see what's going on with this. And a day or two later, I received the proposed order, which was not changed in any way, which also fails to dismiss the count of action for fraud that was authored by defendant VUKELJA. I don't know if Judge Hedstrom ever saw my proposed order or read it, or had completely forgotten about the case until somebody from the Seventh Circuit Court called him, because it sat there unadjudicated for 4 months, Your Honors. And I would also like to continue, I would like to also say that in reviewing my cause of action for fraud. My cause of action for fraud was based upon based upon the defendants using an action that was prohibited by Florida statute for a plaintiff that had no standing, and they knew he had no standing. They knew that the plaintiff had no standing in this case. It was brought against me and used after process to block a legitimately filed trademark with the U.S. Trademark and Patent Office after process, and then later used after process as an inducement to make a more favorable settlement on the case that I had against Mr. VUKELJA's client, Mr. Kafka, and his wife in U.S. District Court, offering to withdraw an action which Mr. VUKELJA quite rightly knew was barred by statute and had no standing, as a means to induce a more favorable settlement. And
I don't understand what's the abuse of process after the lawsuit is filed, and it's not the actual filing of the lawsuit. It's how did the party use the process?
Yes, Your Honor.
Okay.
The lawsuit, the fraudulent lawsuit, the lawsuit that is barred by statute, was sent to Mr. VUKELJA's client's trademark attorney, and it was used to block my trademark.
You're talking about the trifecta complaint?
Yes, it was used to block my trademark. My trademark has been blocked for 3 years. It was then used, this case was then used by Mr. VUKELJA's client as proof that, this business was not my business, that I didn't start this business, that this wasn't this was something that he created and it didn't belong to me. It was also used after process as a means of inducing me to agree to certain terms of a settlement agreement that I probably would not have agreed to at that time had I known that this case did not exist.
You were in your rebuttal time, just so that you know.
Yeah, thank you, Your Honors. Yes, I do want to reserve time for rebuttal, but my position is that I want this case, the appeal of this case, to be returned to the lower court for further review.
May it please the court. Good morning, Your Honors. My name is David VUKELJA. I'm here on behalf of myself as well as my associate, JARETT, who at all times worked for David A. VUKELJA, PA, all of us licensed attorneys practicing here in the state of Florida and in good standing at the time when all of the litigation that we've been involved with Mr. Berman has taken place. With regard to the motion for default, I've never understood it from the outset. I'm not trying to be arrogant, but we filed a motion to dismiss, and it very clearly states, come now the defendants, David VUKELJA and JARETT, and it was signed by myself, and that was a timely motion to dismiss. That motion to dismiss was heard. At that time, Mr. Berman's initial complaint, which was one just for abuse of process, was dismissed, and Mr. Berman was told he would be given leave to amend to try to correct whatever deficiencies there were. A second amended complaint was filed. This time there were like 5 counts. It still emanated around the abuse of process claim. The next judge, Judge Gunta, in dismissing same, said, Mr. Berman, please try to correlate your factual allegations with the elements of the claims that you're trying to plead. With that, the case was dismissed, and once again, Mr. Berman was given leave to amend. Mr. Berman filed his second amended complaint, which was then heard by Judge Hedstrom. And again, when I appeared for the first argument on the motion to dismiss, it was Mr. Berman's contention that a default was due to be entered against Mr. DePaula because he did not appear to argue. When Mr. DePaula appeared for the second argument on the motion to dismiss the amended complaint, it was Mr. Berman's contention that I was now due to have a default entered against me because I wasn't present. When both of us appeared at the last argument, merely for the purpose of trying to forego any more discussion regarding default and use what precious little time we had to focus on the motion to dismiss, it still wasn't satisfactory. So in any event, at that point, Judge Hedstrom denied the motion for default, and we heard argument on I believe it was the second amended complaint. The nature of the claims that was brought by Mr. Berman were fraud. Harassment / emotional distress was count 2, count 3 was abuse of process, count 4 was wrongful interference with advantageous business relationship. There are no allegations in the complaint as to count 1 as to any communications or misrepresentations between myself and Mr. DePaula or Mr. Berman other than what took place at the courtroom at hearings and what have you. So there are no misrepresentations alleged to support the fraud claim whatsoever. With regard to the other claim, the harassment / emotional distress claim, we interpreted that for the sake of arguing it to be some sort of a claim for intentional infliction of emotional distress. And with that, we would respectfully submit, as we argued below, there were no allegations indicating any kind of outrageous conduct. Mr. Berman set forth a litany of things that he thought were either unfair or inappropriate or what have you, but none of them satisfied the stringent criteria to allege a claim for intentional infliction of emotional distress. With regard to the abuse of process claim, the only process was the filing of the complaint, which in and of itself doesn't qualify. There was no process to follow. Primarily due to the fact that the lawsuit that I had filed along with the trademark application he alluded to a moment ago, along with a number of other lawsuits that he had filed, had all been settled. It's a confidential settlement agreement. I'm just going to comment on what's been made part of this argument, but my point is the underlying litigation that I filed was settled, as well as the trademark registration that Mr. Berman alludes to now. In any event, returning to the second amended complaint, the last count was wrongful interference with advantageous business relationships. Mr. Berman did not identify any business relationships that my associate and I interfered with. He didn't explain how we would know any of the business relationships he was involved with, and didn't allege with any specificity how we interfered with those relationships or how our wrongful interference somehow culminated in damage to him. So, focusing on the second amended complaint, I would respectfully submit that Mr. Berman was given ample opportunity and, quite frankly, I don't want to say coached, but counseled by the court as far as how a pro se plaintiff would go about trying to fashion an appropriate complaint. And notwithstanding all of that, he still failed to do so. So with that, I would respectfully submit that the court's order dismissing or denying the motion to default with prejudice, as well as the court's order denying or granting the motion to dismiss with prejudice was appropriate, and we respectfully request that this court uphold it. If the court has any questions, I'm happy to answer them.
I have one.
Otherwise, that's...
I just have one question.
Yes, sir.
In the order, the trial court made some, or engaged in some discussion about absolute immunity.
Yes, sir.
And I'm questioning whether that's looking outside the pleading to determine its ruling. You want to comment briefly on that? Mr. Berman complains you can't look outside the four corners of my complaint. There's nothing in there about immunity. That immunity was raised at the hearing. There's some conversation about it in the trial court's order. What are your thoughts about that?
Well, the argument was raised in the motion to dismiss because the nature of all of the allegations that Mr. Berman were asserting all arose in the context of judicial proceedings. And so the motion was made at that point in time that we would be entitled to absolute immunity, as would a court, as would witnesses, as would countless others, when it comes to actions taking place within the judicial context. And everything that he was alleging either occurred in the judicial context or emanated from the judicial context. There was nothing that occurred outside the purview of us appearing at court proceedings, us participating in court proceedings, my having to communicate with Mr. Berman because both federal court procedures as well as state court procedures require that we confer with counsel or opposing parties to try to reconcile matters, to schedule matters, things of that nature. So my point is all of the communications and all of the interaction between myself, my associate, and Mr. Berman was in the context of judicial proceedings. There were no extrajudicial communications involved here whatsoever. And it was our contention that we were absolutely immune from any liability for allegations alleging activities that it was our contention, or based on the pleadings, the court could discern for itself, arose clearly and exclusively in the context of judicial proceedings.
All right, thank you.
Thank you, Your Honors.
You have about 3.5 minutes.
Thank you, Your Honors.
Okay, let me address the issue of being outside the four corners of the complaint. There's a second area outside the four corners of the complaint that's not raised. Mr. VUKELJA's answers in the motion continually state that the basis of the complaint is that he mistakenly referred to me as an employee as opposed to a owner and shareholder of the company. Okay, that's outside of the four corners of the complaint. Mr. VUKELJA never addressed the fact that his client lacked standing, that he was in default of Florida Statute 607.0501, which specifically says that you must maintain a registered agent in the state of Florida. To not do so means you are prohibited. You cannot bring or maintain an action in a court in the state of Florida. And you cannot file false representations to the Florida Department of State. That is a criminal fraud. That is a third-degree felony under 817.155. Mr. VUKELJA and Mr. DePaula were aware that their client was filing false documents. They were aware that their client was committing fraud, and they were assisting their client in the perpetuation of a fraud. That completely invalidates any idea of absolute immunity. Absolute immunity does not allow for the perpetuation or the assistance of a client in fraud. Also, many of the items that, or many of the arguments that Mr. VUKELJA made for absolute immunity were based under Levin. Okay, Levin was superseded by Delmonico versus Traynor in February 14th of 2013, which greatly narrowed the scope of absolute immunity, which makes most of his arguments in the case moot. I would like to sum up my points. Oh, by the way, I have the actual statute for 607-0501, and which says an individual who resides in this state whose business office is identical to such registered office. The registered agent can be a director or an officer of a corporation as long as he or she is a Florida resident and has an office registered in this state. And it says a corporation may not maintain any action in any court in this state until the corporation complies with provisions in this section. Mr. DePaula claimed that this was an administrative error, and it was cured. And it's case law that a standing must exist at the beginning of any action. The action was an illegal action used after process to block my trademark, to disrupt my business relationships, and used as a false inducement. And that case that Mr. VUKELJA is speaking about as being settled, that case is still under appeal. I am filing a petition for certiorari.
All right, thank you. Your time is up.